First up, we're in Las Vegas, Nevada, where 27-year-old Jimmy Carter Kim is in court to determine his competency to stand trial. Kim pleaded not guilty to 83 felony charges, including kidnapping, sexual assault, battery, and lewdness with a child. The charges stem from two different incidents in which he allegedly drugged, kidnapped, and raped two underage teenage girls who he held captive in his bedroom.
Can I have a say?
Pardon me?
Can I have a say in this?
Well, I tried to give you a say, but you refused to talk to the doctor.
No, I spoke to the doctor.
Well, there was a second doctor, Dr. Paglini, you refused to speak to.
Under Nevada law, a defendant must undergo 2 independent psychological evaluations before a judge can make a ruling on competency. In Kim's first evaluation, he was found incompetent, but he refused to speak to a second doctor.
Mr. Kim, pursuant to Nevada law, NRS 178.415, I'm remanding you custody, transported to Lakes Crossing or Sinai Hospital for further observation.
I don't see what the relevance of me, why is my competency in question?
Because your lawyer challenged your competency or questioned it. I appreciate that you don't agree with Nevada law. I apologize that you don't agree with it. It doesn't really matter whether you agree with it or not.
What so far has been a respectful dialogue between judge and defendant is about to take a strange turn.
Well, can I ask you something? A young gentleman like me, young, charismatic, and fetching in these county blues, why would I be subjected to competency hearing or to an evaluation when I'm clearly cognizant of everything I'm doing? It's rubbish.
If only fetching were the standard, I'm not going to argue with you. In the meantime, you're going to Lakes or Stein. Thank you.
As officers escort Kim out of the courtroom, the Las Vegas local drops some choice British phrases.
State versus Eldrion Wilson.
After undergoing a second psychological evaluation, Kim is found competent. He entered a not guilty plea and is set to go to trial.
Rubbish.
We head to Seattle, Washington, and the King County courtroom.
This is State of Washington versus Christopher Teal, cause number 181008391, Seattle designation.
Christopher Teal is accused of first-degree rape and unlawful imprisonment. Teal allegedly followed a woman into the bathroom of a car dealership, locked the door, and raped her. The attack was stopped only after company employees broke into the stall and wrestled Teal to the ground. The defendant's in court for a competency hearing to determine whether he's fit to stand trial. Standing next to him is Reed Birkland, his court-appointed attorney. The jail guard removes Teal's cuffs.
I'm Emily Peterson on behalf of the state. Mr. Teal's present. He's in custody. He's represented by counsel, Mr. Birkland.
He raises his arm toward Birkland, but extra security's at the ready.
My understanding from his counsel, who I'll defer to in a moment.
Without provocation, Teal punches his own attorney.
Get down! Face down! Face down! Put your hand behind your back!
The guards immediately pounce on the 6'3" defendant and take him to the ground. Teal's attorney looks to be unhurt.
Put your hand behind your back.
It takes 4 men to subdue Teal, and even then, he refuses to go quietly.
Bring the chair. Bring the chair.
A spit hood is placed over his head as officers return him to jail. Birkland chooses not to press charges, but he does remove himself from the case. Nearly 2 weeks later, Teal returns to the courtroom.
New counsel has been appointed since the last hearing.
This time strapped to a rolling chair.
New counsel needs time.
His biggest concern is how his hair looked in his mugshot.
I got one question, one thing to say. I'd like to know where the they got that photo of me with my short hair. Because that was on Facebook, and I don't have a Facebook.
All right.
So you're on the... legitimate question. Like, do they have access to Google?
The judge schedules another hearing in a week's time. and the trial has yet to begin. We go to a pretrial competency hearing in Seattle, Washington. 22-year-old Abdi Ali Abukar has been charged with unlawful possession of a firearm, robbery in the first degree, and burglary in the first degree. Today, dressed in his red jail uniform, Abukar appears before Judge Palmer Robinson, who's seated just off camera behind this law clerk. Things seem to be moving along until the prosecutor and defense attorney begin arguing about Abukar's mental health. That's when Abukar explodes.
Whoa!
The defendant takes his jail-issued sandal and throws it directly at Judge Robinson.
Whoa!
He's then quickly tackled by deputies. According to the judge, the slipper struck her in the chest and mouth. Deputies then placed the defendant in cuffs.
All right, kid. Come on, get up.
Once Abukar is subdued, deputies check on the judge.
You all right now?
Yeah, I'm fine, thank you.
A few minutes later, the hearing resumes. And once again, both sides argue over the defendant's mental state.
If he's angry, he is confident.
I think it's more than just that he is angry. I'm angry. I think there's something more than that going on.
For throwing the sandal, Abukar was charged with fourth-degree assault. A week later, Abukar was brought back to court, this time wearing a white ultra-security outfit. The judge ruled the defendant be moved to a hospital for psychological evaluation. 3 months later, Abukar was ruled competent to stand trial and later pled guilty to first-degree robbery and first-degree burglary. The weapons charge was dismissed. He was sentenced to 42 months in prison. As for the assault on the judge, Abukar pled guilty and was sentenced to 2 years probation and ordered to pay a $500 fine. Let's go inside the Jefferson County Court in Lexington, Kentucky, for the competency hearing of murder suspect Jerry Lawson. Lawson has had numerous prior outbursts in court. Prosecutors believe what you're about to see is all an act to avoid a trial. Lawson's charged with murder, arson, tampering with physical evidence, and abuse of a corpse. Police say he torched the home of Vernice Aniton. The 64-year-old woman was found dead, and following an autopsy, police announced her death was suspicious. Today at his pretrial hearing, Lawson waited mere seconds before exploding into a rage against his own attorney, Mike Lemke.
You all right, Mike?
Yes, sir.
Okay. I mean, I don't know what they're going to do.
Once things settle down, the prosecution explains they've seen this performance before, and just like previous times, they're not buying it.
But the competency evaluations, there's been 2 of them, and Dr. Allen's diagnosis has been consistent from 2013 to now that he's malingering, and that all of this, and every time we come to court, is completely a show.
The case has to go forward. Maybe, the next time it comes up, and that'll be true whether he needs to be restrained or whether he gets to stay out here or not.
Despite Lawson's theatrics, the trial eventually took place. He was convicted on all charges and is currently serving up to 85 years in the Luther Luckett Correctional Facility in Kentucky. Next, we head to the Washtenaw County Trial Court in Ann Arbor, Michigan for a hearing. The defendant, Donald Roberts, is accused of unarmed robbery, refusing fingerprinting, assault with intent to rob, and larceny. Roberts had been representing himself in the matter, but the man standing next to him is attorney John Vella. Vella was ordered by the judge to be Roberts' standby counsel. Roberts had just finished telling the court about the poor state law library in jail and telling the court that he had no need for an attorney. Assistant Washtenaw County Prosecutor Brenda Taylor responds.
Your Honor, I'm asking the court to use the report dated July 25th of Dr. Smith for purposes of finding incompetency, and I'm asking the court to find the defendant incompetent and to order him to the Forensic Center for treatment and restoring of competency. I have prepared a proposed order. I don't want to reiterate the other issues that have already brought us here. If the court wants me to respond regarding the law library, I can.
No, I've already ruled on that.
While his competency issue remains in question, Roberts has a question for the court.
What about my discovery? Let's talk about that.
Oh, let's not. Not right now.
Not the answer Roberts was looking for.
Oh, let's not. Not right now.
Roberts snaps and then off-camera attempts to lift and knock over the lectern as a stunned Judge Swartz looks on. Roberts then charges at attorney John Vella before being quickly taken down by deputies. As the deputies move in, this woman carefully finds her way out by walking across a row of chairs to safety. The defendant is hauled away by deputies. Judge Swartz orders a competency hearing, and despite Roberts' obvious objections, appoints Vella as his representative. Roberts was eventually declared competent and pleaded no contest to larceny, while the other charges were dropped. He was sentenced to 1 year and 10 months in jail.
On record 03CR0288, Commonwealth versus Percy Allen Phillips.
Next, we head to Jefferson County Circuit Court in Louisville, Kentucky.
Jay Lambert on behalf of Mr. Phillips, Your Honor. He's present and seated next to me.
A hearing is underway to determine if 45-year-old Percy Phillips is competent to stand trial. Phillips is accused of retaliating against a witness inside the courtroom during a previous trial.
And it would be our position that Mr. Phillips is presently incompetent to stand trial. If we end up in trial, there is no way I can competently even frame a defense. I have asked Mr. Phillips, what do you want me to say or do at your trial? And he won't tell me. He literally, for years, has not said a word.
Before turning things over to the prosecution, Phillips' lawyer issues a warning.
Mr. Phillips has shared that he doesn't know exactly what he'll do in certain situations in the courtroom. He thinks he just may explode.
Now it's over to the prosecution.
Your Honor, it's interesting to remember that the conclusion of the case, when the defendant was unhappy with the verdict and unhappy with the sentence, he threatened the police officer who testified against him.
Man, you a goddamn black. You up, man. Who got first thing? I ain't.
Day was 16 to 239. I had to stun Percy Phillips. You want to come on up?
Remember that just moments earlier, Phillips' attorney seemingly predicted what was about to happen.
He thinks he just may explode.
After sitting for more than 20 minutes without showing a single emotion, Phillips erupts.
You a mother
and heads towards the prosecutor's table.
black.
Phillips is first grabbed by this deputy. What you can't hear on the tape is another deputy in the corner of the courtroom yelling the word taser. This is a signal for the other officer to move out of the way.
First thing, I ain't.
Waiting for emergency personnel to arrive, the judge looks around her disheveled courtroom in disbelief.
Percy Phillips, he's laying on the ground.
Percy Phillips is later deemed incompetent, and the indictment is dismissed. This is not the last time Phillips will see the inside of a Kentucky courtroom. While incarcerated, he's brought up on murder charges after his fingerprints link him to a 2-decade-old homicide. Next, we're at St. Joseph District Court in Centerville, Michigan, where 30-year-old Brad Johnson's been charged with 2 counts of criminal sexual conduct in the 2nd degree and sexual assault. Johnson's scheduled for an upcoming competency hearing, but today Judge Jeffrey Middleton checks in with attorneys from both sides of the case in advance of the hearing. So far, Johnson has not been cooperative with the court, and 2 weeks earlier, the judge sentenced him to 30 days for contempt. Today is not off to a good start either.
We're all holed up waiting for him. I would respectfully request his presence.
After a few minutes, a sergeant from the sheriff's office brings Johnson into the room, although he's not on camera.
Here we go. Mr. Johnson, can you hear me?
He can hear you.
All right, Mr. Johnson, so far you've been particularly uncooperative about appearing when you're supposed to be. We need to move this case forward. Your lawyer, Mr. George, is here. Are you willing to speak to him?
Simply, George is not my attorney.
All right. Mr. Johnson, would you have a seat in the chair?
No.
Mr. Johnson, you can't avoid this case by simply saying, I don't want to participate. I'll continue to find you in contempt.
Johnson has just left the room.
He just walked out. At some point, I'm going to ask that he be put in a restraint chair and have his skinny ass dragged back in that room.
They're trying to.
Sergeant Hasbrook?
After a few minutes, Johnson returns.
He's right there. All right. Mr. Johnson, have a seat.
The defendant does what he's told. Sort of.
Mr. Johnson, you need to be in the picture, or I'm going to have them put you in the restraint chair and wheel you in there so you and I can speak.
Finally, Johnson slides over and appears partially on camera.
Talk about passive aggressive. Mr. Johnson, you told me several times that you have your own lawyer, who is your father or stepfather or somebody. Do you have someone who is going to appear to represent you on your own behalf?
As Johnson remains silent, the judge announces next steps for the case.
We're going to have a hearing next week. You're charged with very serious sexual assault crimes, and you're not going to avoid them by just putting your hands over your ears. Well, that was not very successful.
A week later, despite more shenanigans at his competency hearing,
Mr. Johnson, do you have a seat for a moment so you and I can talk?
Johnson was ruled competent to stand trial. Judge Middleton denied the motion to withdraw public defender Timothy George as Johnson's legal counsel. His case is pending. Thanks for being a fan of CourtCam. Subscribe to A&E to never miss a new video and catch full episodes on aetv.com.